Thank you, Worship. I am ready to address if the court is willing to hear us.
Worship, I'm not sure, just not in relation to this matter. There was a matter that Ms. Rand approached me about. It's also a partly heard matter before you, Worship, and you had indicated that the IO would be coming together with Ms. Selani. I'm not sure if the Worship was sensitized to that and what the end outcome was, and as far as that other matter is concerned.
What time is it now?
It's now 15:35, almost 20 to 4. I know my colleague can address, but I don't think I will get my time to address. I'm not sure. But I heard it that initially had mentioned that his schedule might be an issue. So if he's ready to address, then he can address for purposes of convenience, and then should time not allow us, then maybe we'll postpone the matter for the state to make its submissions. I'm not sure. My colleague will also filter in as far as that is concerned.
If the court is willing to hear me, then I'm ready to address the court on that question. Bishop, I think an apt portion to start off with this application is to look into the schedule under which this application falls. Now, as the court knows, it's right law that the charge dictates the schedule, however that it must be borne out of the evidence led. Now, the only reason why this matter resorts under Schedule 5 of the Criminal Procedure Act is due to the extortion charge that is led. The kidnapping itself does not resort under that schedule. What is crystal clear from the evidence led by Colonel Laborde is that there is no evidence linking the applicant to the extortion. Now the question then arises what the court should do insofar as that position. I would submit that it is a factor that weighs heavily in the favor of the applicant. That in respect of that specific charge, bringing it within the ambit of Schedule 5, there is no prima facie evidence. I would submit, Your Worship, that much has been made of the merits in this matter, and I think the court aptly remarked that we are all left wondering exactly what had transpired here. I would submit that even on the kidnapping, there is a lot of questions that still remains. I think Colonel Laborde's answer to say that there is no evidence currently to disprove a theory that the victim was a willing participant is telling. Because without that there is also no kidnapping. The very element of kidnapping should be that it is against the person's will, denying him freedom of movement. Now I would submit, Your Worship, much has been made of the inferences that Colonel Laborde draws from the analysis, as well as a witness, Ms. Amanda Burger, that will be ventilated at trial, and as he correctly pointed out, these admissibility issues at play insofar as that evidence is concerned. But I want to refer the court, when we're dealing with the merits of the matter, specifically towards case law, it is State versus Dlamini, Gladla, Skitakat, and others. It's well-known court case, the full citation being 1999, Volume 4, South African Law Reports, and it starts from page 623. It's a constitutional court matter, and it is, I would submit, the locus classicus insofar as bail applications are concerned in the new constitutional era. And specifically at paragraph 11, the following is said. It is that there is a fundamental difference between the objective of bail proceedings and that of a trial. In a bail application, the inquiry is not really concerned with the question of guilt. That is the task of the trial court. The court hearing the bail application is concerned with the question of possible guilt only to the extent that it may bear on where the interests of justice lie in regards to the bail application. Now, that specific sentence and paragraph has been interpreted to say that it might be in the interest of justice to consider the strength of the state's case, where it's so weak that it might lead to exceptional circumstances being present. What is furthermore telling, Your Worship, if we then take that paragraph and we compare it to the Criminal Procedure Act, and we look specifically where it might have bearing on in terms of section 60 subsection 4A to E. The court will note that the only subsection where it has a bearing on the strength of the state's case is in section 60 subsection 4B, where one of the factors to consider is the strength of the state's case as such that it might lead to the applicant evading his trial. Now, I would submit, Your Worship, it is common cause between the applicant as well as the state that he is not a flight risk. That subsection is not applicable. So I would submit, Your Worship, even if the court finds, which I submit there is no strong case, but even if the court is to find that there is a strong case that the applicant is to face, it does not take us any further insofar as why bail should be refused, because he is not a flight risk, and that is the only subsection where it finds applicability. Now, Your Worship, staying on the very same case, I want to take the court further to paragraph 55 to 58 of that very same judgment. In it, the Honourable Justices of the Constitutional Court had to decide on the constitutionality of section 60 subsection 4E, and that is what Colonel Lebodi testified, and what the state's argument is that the public outcry would be of such that it would disrupt public order. Now, aptly, I think it's important to mention further, the court must have regard to the provisions of section 60 subsection 8 capital A, which says that this subsection is only to be used in the most exceptional circumstances, in the most rare cases. And that is what the Constitutional Court also found. It specifically deals where the constitutionality of this section was challenged, and it starts at paragraph 54. It would be appropriate next to focus on subsection 60, subsection 4E and 8 capital A, which was struck down in Skitakat and Uber, not only because they were held to constitute an unconstitutional deeming provision, but also because it was termed they constituted lynch law. It further goes on to say, further down in the paragraph, looking at public opinion and taking into account the likely behavior of persons other than a detainee, smacks of preventative detention and infringes on a detainee's liberty, elevating the sentiments of the community above the interests of the detainee. And that is exactly the situation, and why it was held to be constitutionally only so because it's to be enacted in the very rare cases where there's a real threat. We have evidence of one group, Your Worship. There is no factual basis to indicate that this is one of those rare special occasions where the court should refuse bail in acting this specific provision. I want to refer the court, whilst I'm on the point of a factual basis. Colonel Laborde correctly indicates that the wording in the Criminal Procedure Act is a likelihood. But there is an abundance of case law which indicates that a likelihood cannot be a mere possibility or speculation. It must be on factual grounds presented before the court. Now I want to refer the court specifically. The first case being State versus Diale, D-I-A-L-E, full citation being 2013, volume 2, South African Criminal Law Reports, page 85. It's from the Gauteng North High Court in paragraph 14. I quote, "A court cannot find that the refusal of bail is in the interest of justice merely because there is a risk or a possibility that one or more of the consequences mentioned in section 60 subsection 4 will result. The court must not grope in the dark and speculate. A finding on the probabilities must be made. And unless it can be found that one or more of the consequences will probably occur, detention of the accused is not in the interest of justice." I think on a last point, I must also refer on that point to refer the court to State versus Koch. It is a Supreme Court of Appeal decision, the full citation being S. Koch, K-O-C-K. The citation being 2003, volume 2, South African Criminal Law Reports, page 5. As I mentioned, the Supreme Court of Appeal decision, and I'm quoting from paragraph 20. What was clear on the record but was overlooked by the magistrate was that there was no evidence that the appellant had attempted to influence witnesses prior to or after his arrest, that the opportunities for contact with the boys had arisen and been pursued in specific contexts of his employment as a teacher, that such employment had been terminated, and that the appellant had said under oath that he would make no contact with them if released. I would add that in the evidence as a whole, there is no suggestion that the appellant used intimidation in his relationships. The conclusion that the likelihood existed that the appellant would interfere with the investigation or state witnesses was, for these reasons, devoid of factual support. As a possibility, it was no more than speculative. And I would submit it echoes and smacks of the evidence presented in this matter. There is no evidence to suggest that the applicant in this matter intimidated, interfered with the investigations, nor with any of the state witnesses. And I would submit that to state merely because they are colleagues of his, it can only be a possibility based on pure speculation. In the Dladla matter that I referred to earlier, again this specific wording of a likelihood is dealt with in paragraph 53. The important proviso throughout is that there has to be a likelihood, i.e. a probability that such risk will materialize. A possibility or suspicion will not suffice. Worship, I can further refer the court, I'm not going to quote from them, but two important cases is State versus Bennett, B-E-N-N-E-T, 1976, volume 3, SA, page 652, and it's a Cape Provincial Division. And specifically at page 654, it also deals with the factual basis that is required. Now, on that point, Your Worship, in S versus Bennett and S versus Barber, and specifically then in S versus Van Wyk 2005, Volume 1, South African Criminal Laws, Law Reports, paragraph 41, it's a Supreme Court of Appeal decision at paragraph 12. It was stated that the primary purpose in the inquiry of a bail application is, and whether to grant or refuse bail, is whether the applicant will firstly stand his trial, and secondary to that is whether it would be detrimental to the administration of justice. Now I would submit, Your Worship, it's conceded by the state that there is no flight risk. We can accept that there is no likelihood, and we can accept that the applicant will stand his trial. When it deals with the administration or detriment, whether it's detrimental to the administration of justice, we then look to whether the integrity of the investigation will be preserved. I have addressed the court that there is no factual basis to find that there is a likelihood that he will interfere or intimidate witnesses. And I would submit, Your Worship, on that basis, there is sufficient evidence before Your Worship to find that the interests of justice do permit the applicant's release out on bail. I would like to finish off, Your Worship, and point the court, which I believe the court will be well aware of and take cognizance of, is that at the bail application stage, the court always has to take into consideration the presumption of innocence in this matter. That was so reiterated in State versus Dlamini, Dladla and Skietekat, the matter I referred, Your Worship, to earlier, but specifically again dealt with by the Supreme Court of Appeal in Crossberg versus S, C-R-O-S-S-B-E-R-G, Crossberg versus S. The judgment is available on Safley, being case number 439 of 2007, ZASCA, and it is the 93rd judgment of that year, delivered on the 22nd of August 2007 rather, and specifically at paragraph 13, the court reiterates that in a bail application the presumption of innocence is intact. And importantly then, in State versus Atchison in 1991, volume 2, SA Law Reports, at page 805, it's a Namibian decision, and specifically page 822 at paragraphs A and B, the court again finds that there is a presumption of innocence, but goes further to say that a bail application is not there for prospective punishment and to detain an applicant due to the seriousness of the offence. And I would submit, Your Worship, and implore that the court finds that the applicant has shown evidence on oath that it is within the interest of justice for him to be released out on bail. And I would submit that Your Worship then grants him bail as such. My ending remarks would be, Your Worship, that I believe if the court has any fears insofar as the likelihoods is concerned in section 60 subsection 4A to E, the court in State versus Branco in 2007 specifically deals with it, that these fears may be allayed by appropriate bail conditions, and I believe, Your Worship, that if appropriate bail conditions is placed upon the applicant, the court should find that it is in the interest of justice for him to be released. Worship, those are my submissions, unless the court wants to hear me on a specific aspect. Thank you.
Your Worship, the argument that was made by my colleague is in essence what I'll call a Section 35 argument, in as far as his right to the presumption of innocence is concerned. And most of the submissions and the cross-examinations and the evidence in chief was spent mostly attacking the version of the state. And as Worship,
The party had the postponement.
as far as Ms. Wright informed me, she informed me that it opened a separate court, but that was when Mr. Khabis going to assist in as far as the postponements. However, the one matter of Munari is when Your Worship is involved. And yes, Worship. The one of Mutupi, I'm not sure. The one I was doing with Mr. Kalaute before, Your Worship. I'm not sure whether they were able to postpone or not. My colleague was here, and I'm just not sure as I stand, Worship, whether those matters have been fully dealt with, or whether there are any matters that may be waiting for Your Worship. Perhaps unless we could be assisted by one of the court readings in ascertaining from Court 19, we inform the sitting in Court 19 to ascertain whether all those matters have been dealt with, and if the worship would be needed in any of those matters. Not the investigations are also considered. Mr. Musomere is also here for that matter that you requested that he comes for paying when the party had to pay the application. He says he just received a message from Ms. Wright, in actual fact. They say they intend on postponing that matter to a certain date. I informed next week, Thursday, Your Worship. And then I will show whether Your Worship will be available on that day.
I'll be available.
Nothing such to do with Mr. Allowed. Worship, Mr. Kamat is making just as I think the matter might be not already been judged.
Okay, we can proceed. We still have time.
Your Worship?
We can proceed with your argument if we still have time.
It's now 4 o'clock, Your Worship. I don't think I'll be comfortable proceeding in as far as until I feel like I'll be rushed in every point that I want to make. Done, Mr. Worship? I'm not sure as to Your Worship's availability, but as I said,
Thursday.
yes, Worship, next week Thursday, I'm available.
Mr. Van Rensburg.
For this matter specifically. Your Worship, I'm unfortunately unavailable from Monday for quite some time. I don't want the matter to be delayed due to that. I've presented my arguments to you. I will ask that my instructing attorney will take over from me from the next day. But may I just inquire from him if it is indicates he is available.
I think the date on Thursday. The 10.
Yes, it is the 10th, Your Worship. You are right.
Mr. Van Riebeeck.
Bishop, yes, I confirm same. I am available, Your Worship.
Matter is postponed until the 10th of July 2025 for address by the state and possible judgment. You are in custody. You shall remain in custody until then.
Your Worship, I believe that that's the handling matter.
May I just turn my back?
Where's the copy? What did you miss?
I don't know what.